I think I got it. Everything, just those.
7-1, yeah.
Yeah, okay. Yeah, I got those.
37.
Yeah, sweet.
Good afternoon. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such an appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. This procedure of this board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is allowed to ask questions. Then the violator is allowed to make a presentation, and after that, the city can ask questions of the violator. After both rounds of testimony, both on the part of the city and on the part of the alleged violator, each party is asked to give a closing argument, summing up your case, first by the city and then by the violator. After those three steps are taken, the board will close the public hearing portion of the case to discuss it and make appropriate action. Before we begin the public hearings, we'll have all potential witnesses stand up and be sworn in by the secretary of the board. Please turn off all cell phones to silence them. If you're going to testify, she's going to swear you in.
Do you swear the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. You can be seated.
We're going to have a prayer and a pledge of allegiance.
Heavenly Father, we seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We gather to make decisions for our community. May we use only our best skills and judgment, keeping ourselves impartial and neutral as we consider the merits and pitfalls of each matter that is placed before us, and always act in accordance with what is best for the city of Tarpon Springs and our fellow citizens.
Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do a roll call.
Roll. Bobby, will you call the roll, please?
Yes, ma'am. Mr. Weeks is absent and excused. Miss Wade?
Yes, here.
Miss Dabbs?
Here.
Mr. Kramer is absent. Mr. Robinson, absent. Miss Norfleet?
Here.
Mr. DeMassis?
Here.
Mrs. Telliar?
Here.
Miss V. Casey, absent. This completes your roll call.
Thank you, Bobby. For everyone's understanding, we're going to change the order of the agenda just a little bit. What you show as item number 3 will become item number 1. We'll address that first. what you show as item number 7 will become number 2, and item number 1 will become item 3.
We're not changing. Oh, yeah. We'll catch it.
Sorry. Case number 19-800-000077, 1306 Crossbow Lane, Edward and Margaret Carmichael. And you were sworn in, and you are,
My name is Mike. I'm the son-in-law that lives there.
and does he have authorization to speak for that property?
Do you?
I lived there 18 years.
You're not the owner of the property.
Do you have anything? Do you have an affidavit from the owner, or is your,
It's my mother. She's on vacation.
Do you have a letter from her giving you permission to represent her?
No. I mean, I lived there.
that's to the, if the board will allow it? I don't know.
I would object to him testifying based on the fact he has no right to the property, and he's not a listed owner.
You
So
do
the city
object.
would object for him to testify.
I don't have any authority to give you permission to speak on her behalf without any message or note from her. I'm sorry.
So, but
You can listen to the case, and
And Shirley, if you want, for the record, you can sustain the objection.
I do sustain the objection, and I'm afraid that you can listen in, but you're not able to present evidence. It's not your property.
Ready? Officer Steve Gaston, City of Tarpon Springs Police Department Code Enforcement. Case before the board is 19-800000077. The property address is 1306 Crossbow Lane. Property owners are listed as Edward and Margaret Carmichael. Exhibit number 1, going before the board, are all of the photographs. Exhibit number 2 are all of my notices, to include the notice of violation and notice of hearing. Exhibit number 3 are all of my administrative documents, to include the case summary, property appraiser and tax collector records, as well as any related emails. Exhibit number 4 is the affidavit posting and a copy of the sign. All of the, well, we weren't given to the violator, so all the notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collectors databases. All of my notice of violations or notice of hearing are sent return receipt as well as first-class mail. And Madam Chairman, or Chairperson, please accept these exhibits into the record as evidence.
Thank you.
Moving, or are they accepted?
Bobby, will you accept these into the record, please?
Yes, ma'am.
Thank you. We have had contact, well, we've had contact with the son-in-law. We've had actually no contact with the owner of the property. He's made office visits and emailed. Originally, this case started from a complaint from the Stormwater Division of the city around February 6th of 2019. There was work being done on the house, and a driveway was being installed. There was dirt running into the street from the unpermitted work. You can see in the photographs what I think most people would generally agree seems to be a driveway. I can pull the picture up on the big screen here. Give me just a second. So as I pull the picture up, the sidewalk, the city sidewalk was covered with dirt and it was not being maintained. There was some trash and debris stacked on the side of the house, and there's 3 vehicles that appear to be inoperative parked on the property. So one of the first pictures I'll show you, I know, it's not there yet. I'm bringing it over to that screen, is right here. So this is, I'm on Crossbow, the street, looking to the north along the side of the house, which the house is 1306 Crossbow, and you can clearly see what appears to be a driveway. It's not been developed, but it's being used as such, to the extent where when I was out there on May 9th, I took this photograph of the same driveway, which pretty much convinces me that's a driveway. So, good afternoon, sir.
Ms. Wade, can I just interject, and perhaps you might want to make a note that Mr. Kramer has joined us.
Thank you.
Better late than
Thank
never.
you, ma'am.
And do I need to repeat anything from the beginning for Mr. Kramer, or?
I would, or Mr. Kramer should not vote on this hearing. One of the two.
So, Mr. Kramer, since you're absent, this is case 19-800000077. The property address is 1306 Crossbow Lane. Edward and Margaret Carmichael are the listed owners. I had stated all of my photographs were Exhibit 1, notices of violation, notice of hearing were Exhibit 2, admin, docs, case summary, property appraiser, and tax collector records, and any emails were Exhibit number 3. Exhibit number 4 is the affidavit of posting. All my notices were mailed to the property owner of record based on the Pinellas County property appraiser and tax collector. All my notice of violations and notice of hearing are sent first class as well as return receipt, and we accepted all those documents already into evidence. So this started on February 6th, as I stated. There was some work being done on the house. There was a pile of cinder blocks behind it, and then the driveway. Fast forward to very recent, which I'll show you a picture of. The driveway still exists. There's been no permits pulled to actually create an improved driveway or fix the dirt path and make it grass or something again. There's still some work being done on the outside of the house, but it looks like siding work, which the building department has kind of said doesn't seem to be an issue for permitting. But there are still a couple of vehicles parked on the side of the house that are, well, one's just a frame, so I think in my lack of mechanical experience, the fact there's no body or engine in it, it's not operable. And I will bring up a picture of that. Here, I have to deal with two screens, so this is some of them that are still on the side. He has gotten rid of, I believe, at least one of the vehicles. There was a frame and one other vehicle there at this time. So basically, moving forward, on February 19th of this year, the notice of violation was sent. On May 9th, I conducted a reinspection. We had done extension requests from March 8th up to March 8th and then up to June 12th. So as I stated, the case started in February. We've had communication with the tenant. He's asked for extensions. We continually extended it out. When I inspected it on May 9th, there were still vehicles with no tags on the side of the house, and as I stated, a vehicle that was just a frame. On May 2nd, the notice of hearing was mailed. All the mail was returned unsigned to the office. On May 31st, I posted the property and an affidavit of posting was completed. I did another inspection on June 12th. Yesterday, and I noted that there was a vehicle frame and other vehicle still there, and the driveway still exists. What's before the board at this point in time? I'm going to remove I'm going to leave 8-52 because it also covers debris, which can be unused vehicles or unused equipment. So what's before the board is City Ordinance 6-1, which adopts the 2017 Building Code and the 2018 International Property Maintenance Code. Under the International Property Maintenance, under the Florida Building Code, 105.1 requires permits for that type of work to be done. 40.00 is parking and storage of abandoned vehicles or inoperable vehicles. They require both to be operable and have current valid registration. I've been provided no proof of any registration, and as I stated before, I'm pretty confident that the one vehicle as a frame is not operable. And then 8-52 are nuisance prohibitions that cover a myriad of things, debris, unused equipment, which also includes vehicle parts, things like that. At one point in time, there were some tires on the side. I can't testify that they're still there or not. So they were previously, but that's also covered under the veil of 852. So at this point in time, the city has nothing further than what's presented.
The board have any questions for staff? Would you like to summarize your case, or do you feel that was sufficient?
No, I think we've covered that all with the body of it.
The public portion of the case is now closed. We're ready to entertain a motion.
I'll make a motion. I move based on the testimony, evidence, and facts presented and law that at the time of the alleged violation, sections 6-1, 105.1, 40.00, and 8-52 of the city's Code of Ordinances for Tarpon Springs were in force and effect, and that the respondent is in violation thereof.
Second.
Is there any other discussion from the board? Bobby, would you call roll, please?
Mrs. Telliar,
Yes.
Mr. Demasis,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Wade.
Yes.
Motion carried.
Do you have any input regarding a fine or recommendation for a time frame?
We haven't had any, there was prior cases back in 2009 for building code, but I don't know what the status of those were. He has no open, they have no open cases at this time. In speaking to him, he had asked for 30 days and he needed more time for permits. So I think the city, it's reasonable to establish like 60 days to get the permits. And also get rid of the vehicles. I know we have talked to him, the tenant, and he's working on it. But unfortunately, we were already good 6 months into the case as it was. So I think if we go 60 days and then $100 a day moving forward, it should expedite the process.
Board, anyone like to make?
I'll make a motion. I move that the respondent shall have until August 15th, 2019, to bring the property into compliance with the code sections indicated above, and if not, will suffer a fine of $50 per day for each day thereafter the respondent remains in violation of those code sections.
Bobby, would you call roll, please?
Mrs. Tellier,
Yes.
Mr. Demasis?
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Wade.
Yes.
Your motion carries.
And why did that come into him?
So, sir, the board has found you in violation of the city codes. You will have until August 15th to correct them. Otherwise, after that, it'll carry a $50 per day penalty.
Thank you.
You can talk to them. Yeah, if you don't mind.
To clarify, the next case is listed as number 7, and we changed it, Mr. Kramer, to number 7 is now number 2.
Harrison Street.
You bet. Take care.
This will be agenda item 19-800000210, 209 East Harrison Street, Safford Land Trust, Victoria Jones. Is there anyone here for that case? Thank you, sir. You've been sworn in, correct? Thank you. So the city will present their case, and then you can ask questions. Then you'll present your case, and they can ask questions. Okay?
Yeah, I can ask questions.
After he finishes, yep.
Who is this?
And this is item number,
The person?
and you are representing this property, sir?
Yes.
And you are the,
Property owner.
And I object to that. That'd be me.
So he has an
I have
objection.
a quick claim deed filed with the Pinellas County Court System, 2013, shows the property is owned by Safford Land Trust. The trustee of that is an attorney, Luis Garcia Rivera, and the successor trustee is Victoria Jones. Nowhere on there does that list Mr. Wallace anywhere on the deed as any rights to the property. He had previously been the vice president of a company in 2012 that quitclaimed the property to the trust. It's not a probate trust because I pulled that and there's no probate listed. So there's only the trustee and the successor trustee listed, of which Mr. Wallace is neither.
is neither
So I
one.
would object to him testifying on behalf of the property.
I sustain that objection. Thank you. Would you like to present your case, please?
Thank you. This is case number 19-800000210, property address 209 East Harrison Street. The name of the property owner is Safford Land Trust. Victoria Jones is one of the trustees.
You won't be able to.
Excuse me, you say I can't testify?
You don't own the property?
I own the property. I'm a owner of the trust. Victoria is the trustee of the trust.
And as I stated, he's obviously not Victoria.
Sir, the Officer Gasson has objected to you testifying because you are not a trustee and not on that, not on the any of the land trusts. The board has already ruled on that and sustained that objection.
Okay, because if we ask for a recess for Victoria to show up, she lives about 10 minutes away from here.
I would object to that as well. We're here prepared, and this case has been ongoing for a while. It can be handled during an appeal process if they'd like.
That is to the board.
I'm going to overrule that, and if she shows up before the end of this meeting, then we will
That's fine.
move it on the
So we're going to table this one for now?
table it for now, please.
Okay.
Thank
Okay.
you.
I will when we present the case, yeah. The quash. We have a quash.
That puts us to what's listed on your agenda as item number 1, and it's now item number 3. And before we address that, we have
I'm trying to find it.
a request to quash.
Yes.
So we're
and I
going to
have
address
find
that
it.
first, please. Thank you.
Thank you. This is case number 18-800000109. The property address is 710 North Avenue. The city is requesting the previous board order issued in that case be quashed. The property owner listed for the code board hearing on April 2nd, 2019 was Otalia Andino. There was a quick claim deed filed on February 4th of 2019, adding Mr. Pierre Fowler to the deed. Since the quick claim deed was filed prior to the code board hearing, we're quashing that one. And if the board accepts that, we're moving on to a new case at the same address.
So we need to have a motion to quash.
No, so Officer Gaston has already made the motion to quash,
Okay.
so the board has to accept that. So you can move to accept it.
Voice vote or
I'll
roll
second that,
call?
I'll second his motion.
Right, so this is,
Let's do a roll call, Bobby, just to make sure.
Quick, who made the first motion, please?
so the officer made, Officer
Initial
Gaston made the
motion,
motion,
thank you.
but it's an action evidentiary question, so the chair can rule on this, but as a board, you also can. So a proper motion could be if someone would move to accept the motion to quash, and then second. So,
I move to accept it.
Okay, thank you.
and then there would be a second if you,
I'll second.
okay, and then you can do roll call. That's fine.
I second it.
Thank you, ma'am.
We got all kind of ones.
That's right, absolutely.
All right, thank you. Ms. Telliar,
Yeah.
Mr. DeMossis?
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Wade.
Yes.
Thank you.
Okay, so now the prior code enforcement board order has been quashed, and now,
Thank you. So the case before the board now is case, oh, I'm sorry, Madam Chairman, the folks are here on this new case.
so this is the new case, if you'd like to read it.
All right, we're going to introduce case number 18-800000109, 710 North Avenue. Odalila Andino and Pierre Fowler. Yes, ma'am. This Pierre? Yes. Thank you.
Okay, case number 18-8000109, the property address estate is 710 North Avenue. The property owner's names Otalia Andino and Pierre Fowler.
Can we have the evidence admitted while you're speaking, please? Do you have any objection to the evidence being distributed? No, ma'am. Thank you. Thanks so much. Bobby, will you accept that into the record, please?
Yes, ma'am.
Thank you. Exhibit number 1 before the board are all my photographs. Exhibit number 2, notices to include notice of violation, notice of hearings. Exhibit number 3, administrative documents to include case summary, property appraiser, and tax collector records, and any officer emails. Exhibit number 4 is the affidavit posting and a copy of the sign. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to this board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both return receipt requested as well as first-class mail. And Madam Chairman, I believe you already have accepted these into evidence, but please do so if you haven't. Moving forward, we have had contact with the owner. She's visited the office. We've been in communication with her. As we previously stated from the previous quash order, which was more or less a paperwork kind of an issue, this case has kind of been back and forth through the code board for a little while. It's an old house. It was originally owned by a gentleman who unfortunately passed away. These folks had bought the property in the state that it was in. It was still an ongoing case, so we're just trying to get it to some sort of a expeditious resolution. So back to December 4th of 2018, it was sold to Happy Homes, represented by the registered agent of Otila, I hope I'm saying your name right, Otalia Andino. And, so we courtesy lettered her on January 2nd, part of that was to get permits. The structure's in really bad shape. I'll show you some pictures here again, but basically the roof's missing. It needs substantial work. She has pulled a remodel permit with the city, and I was out there yesterday and actually a picture of a guy on the roof, so obviously they're working. They have construction materials there. So there is a process going on, and basically I'm just kind of covering the bases to make sure that process doesn't stop, so to speak. So moving forward through the beginning of the year, on January 22nd, there still weren't any permits issued. January 22nd also, we observed that a quitclaim had changed, and we got new owners via that quitclaim. So we did notice of violations and notice of hearings again on January 22nd, posted the property on February 2nd of 2019. We conducted a final inspection on February 13th. Still no permits had been issued, but a permit 19-289 was applied for to the city. It just hadn't yet been issued. So we had a code board hearing in February 14th of 2019, and we held off, and then we found out there was another quitclaim. So quashed that order. We're back again. May 22nd, the remodel permit was issued on 3/8/19. Works begun. It's just not completed. No inspections by the city have been done yet. And so therefore, it's not in compliance. As we stated, we found the quitclaim issues. Notice of hearing and the quash order were mailed to the property owners on May 24th. I posted the property May 31st. On June 12th, as I stated yesterday, I conducted another inspection, and I will put it on the big screen for you, and observed work being done. So, as I stated, there's a gentleman up cleaning out the roofing material. The property has, I'm not a builder, but it has a substantial amount of work. These guys, if you want to ask them about it, but it doesn't have a roof. There's basically no interior walls from what I understand, and it's some work, but they are working on it. So, but at this point in time, it's still a violation of City Code 8-40, which is just nuisance prohibitions because of all the stuff. 8-52 being a dilapidated structure, unfit for human habitation, so on and so forth. And then I think it'll probably get taken care of at the end, but the fence, you'll notice, is missing. It's for obvious reasons, but there's a fence out back too that's in pretty poor condition, and I would assume that's probably all going to be wrapped up with the building process. So it's those three codes, 8-40, 8-52, and 36.03 that are before the board. Although there's no fence permit, like I said, I would assume that the fence is going to be taken care of. If you're taking care of remodeling a house, you're probably going to fix the fence. So that's what's before the board at this time, and I have nothing further as of now.
Do you have any just questions for the officer? Just questions. You'll get to present your case too.
Yeah. When I brought through the survey regarding the back,
Will you pull your microphone up?
I just can't hear you. We can't hear you.
Needs to be recorded.
when I brought the survey over to your office regarding the back fencing, that is not on my property.
I thought part of it was.
No.
Okay, well, you still have the front fence,
But
so
I am.
just make sure, you just have to be responsible for what's yours.
Yes, I'm gonna.
As long as you can legally prove it's yours, that's all I care about.
Thank you.
Would you like to present your case now, please?
Yes. The reason why the quick claims kept changing, I had purchased the property through my business, and when it was time to pull permits, I couldn't pull the permits necessary because it was under my business, meaning a homeowner's permit. So I quick claimed it to myself, and I added Pierre, which is my kid's father, and that's where all the issues with the quick claims came in.
Okay.
We took care of it, and like he said, March 8th was when the permits were finally issued. It took us about 4 or 5 months to get the permitting taken care of. We finally got a permit, and we're taking care of it. Hopefully within the next 4 or 5 months, it will be all taken care of. I have engineer plans that you guys can take a look at. She told me if I submitted them, you guys will keep them, and these are the ones that were actually has to stay on the property for the permitting people. So you guys are more than welcome to use them as a reference.
I understand.
But other than that, I'm pretty cool with Mr. Gaston. I think we're taking care of everything that needs to be taken care of.
Does the board have any questions for this owner?
Yes.
Mr. Gaston, is that just one structure? Because it looks like there's something else behind there.
It's You might want to ask them specifically. I can't really see the back. The back is fenced. There's a vacant lot to the west of it that I really can't see the back of the structure. So I can't tell if it's just like an add-on or a separate building.
No, it's all one structure. It's a funny, because the guy who owned it was a masonry guy.
Yeah, he
so
liked
he
brickwork.
kind of shaped the house weird.
Okay. And so that back portion will also be taken care of? in
Yes,
your-
the whole, I pulled the permits, and like I said, I have engineering plans of showing of what is gonna get done. And the roofing we're snatching off right now, and it will have a new roof.
Okay, thank you.
No problem.
And I just have one question for them. Do you guys have a time frame? Do you think that you'll be completed?
About 4 or 5 months.
Okay.
It would have been sooner had I not known that there was that much trash. Literally, I had over 10 of the 20-foot dumpsters come in already.
Gotcha.
Yeah.
Public portion of the case is now closed. Would the board like to make a motion?
I'll make a motion.
Thank you.
I move based on the testimony, evidence, and facts presented and the law that at the time of the alleged violation, sections City Code 8-40, 8-52, and City Code 36-03 of Code of Ordinances of the City of Tarpon Spring was in force and effect, and the respondents were in violation thereof.
Thank you. Motion has been made and seconded. Bobby, would you like to call roll, please?
Mrs. Tellier,
Yes.
Mr. Demosis,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Wade.
Yes.
Please.
The motion is passed. I'll ask for a recommendation from the city with regard to compliance and fining.
I think the city it would be reasonable for December 18th of this year at $50 a day. That's a little over 6 months, right about 6 months. Should give them plenty of time to take care of it and that would be that you're signed off on, your permits are finalized and everything's done.
Perfect.
Okay.
Do they need a certificate of occupancy at that point for you to?
They'll just contact the office and
Does it
we'll
have
be
to-
able to look and see if it's been finalized.
Okay.
So,
Thank you.
I do have one question. I did update my address with the property appraiser regarding the lettering and stuff. Would you be able to get the new address if you have any questions or any mail and letters? And I think I told Becca that too. Perfect. Okay.
then yes.
The public portion of the case is now closed. I'd like to entertain a motion from the board.
I make a motion.
Thank you.
I move that the respondent shall have until December 18th, 2019 to bring the property into compliance with the cited code sections or suffer a fine of $100 per day for each day thereafter the respondents remain in violation of said code section.
Second.
A second. He seconded.
You have a second.
Mr. Kramer did.
Thank you. Bobby, would you call roll, please?
Ms. Tellier,
Yes.
Mr. Demosis,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Weeks. Oh, Ms. Wade, excuse me.
Yes.
My finger was over the name. Thank you.
If you want to summarize what's been ruled here for you, please?
So you were found in violation of the city codes. You have until December 18th of 2019 to correct all the violations. Otherwise, you'll be assessed a fine of $100 per day. Okay, thank you.
Thank y'all for coming.
Already. I think he's on another property. Oh, but started 439 Lincoln Avenue. Ice cream shop.
Oh, I don't have anything with the shop.
Oh.
The property behind it.
Okay. Perfect. I just wanted.
Thank you.
I think that's number 3, which is the new number 1. Or no, I'm sorry, number 7. Which is number 7.
Anybody? Anybody?
I'm sorry, sir, we can't hear you.
I'm sorry?
He has a question about another property.
He wants to ask him.
Okay, that can be,
This wouldn't
That's
be
not-
the
Not on the
place
agenda.
for that.
yeah, no.
That should be addressed
Yeah,
to the
that
code
could-
board at another time.
There's, the vacant lot is another case that's before the board. Yes, today. Craig Fowler owns it.
He's on the agenda.
That's
for
Pierre Feller.
item Number 8. So he can,
Earlier was Pierre Fowler, so I don't think he's Craig Fowler. You're not Craig, are you? Yeah, so Craig's the owner of that property. I guess the same thing that occurred to Mr. Wallace, you might want to get Craig down here. It is.
We can't
Okay,
have
yeah,
this
this-
testimony
We're not
out of
discussing
order,
it right
sir.
now, but there's one issue still with it. The grease trap is still there. The grease trap is
Have
still
to
there.
move on
so,
to the next
yeah.
item,
So
I'm
Chair, I
sorry.
would recommend you just call the next case.
I would
Yes.
suggest to take a
Then-
recess, but I don't think it's
Yeah,
right
this
that
is
we
in-
have all this conversation in front of the board. We're gonna have to rule on this eventually.
Which one do you want to handle
I'm
next?
going to
ma'am?
go back to item number 7, which we called item number 2 now. I'm calling 19-80000210-209 East Harrison Street, Safford Land Trust, Victoria Jones. Ms. Jones, I don't believe you've been sworn in. We'll have you sworn in with the clerk,
there's
please.
some other ones too. Mr. Chairman, there's several other people in our audience that have joined us. Do you want to swear them in if they're going to
Sure.
testify and do it
If
one
you're
time?
going to testify before the board today, would you also stand and be sworn in? Thank you.
I think Mrs. Marsh is also going to.
And Ms. Marsh needs to as well.
Hang on one second.
We're going to be, if you raise your right hand, we're going to do testimony swearing in. Do you swear the testimony you're about to give is whole truth and nothing but the truth? Thank you, folks. You can have a seat. Just have a seat, Ms. Jones.
Okay. For clarification for the board, we had item number 7, which is now item number 2, and the city's going to present its case.
Thank you.
Officer Gaspar,
sorry, go
I'm
ahead.
sorry. Can we just clarify the people?
she is?
Yes.
I only am authorized to allow Victoria Jones to speak. Is that who you are, ma'am?
Yes, ma'am.
Thank you.
And are you allowing this gentleman to speak on your behalf?
Yeah.
Okay.
Thank you.
Okay. As stated, this is case number 19.
I forgot to bring in the evidence. Sorry.
Okay, that's okay.
Bobby, if you'll accept the evidence.
Yes, ma'am.
Have they been presented the evidence? Do they have any objection to the evidence?
Do you have any objection to the evidence of the city being presented to the board?
That I received.
Any pictures and things you received?
Has they received the?
Yes,
Oh,
they have.
okay.
They
Have
are in
copies
possession
of
them.
all of this already.
Yeah.
Okay, thank you.
Okay, we ready?
Now we'll
All right,
have the-
case 19-8000210, property address 209 East Harrison Street. The property is owned by the Safford Land Trust with Victoria Jones as one of the trustees. Exhibit number 1 going before the board are my photographs. Exhibit number 2, my notices to include notice of violation and notice of hearing. Exhibit number 3 is administrative documents, case summary, property appraiser, and tax collector records, and any related emails. Affidavit number 4 is exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the board are exact copies of what's being presented to the violator. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent return receipt requested as well as first-class mail. And finally, Madam Chairman, please accept all these exhibits into the record as evidence.
Thank you. Bobby?
Yes, ma'am.
We have had contact with Mr. Wallace. We haven't had any contact with the direct owner of the property via phone call and emails. Case started April 1st. The initial inspection was the Police Department Patrol Division requested I conduct an inspection for possible violations at the address. Apparently, they had some contact with people related to some drug activity at the address. At the time, I noted there was a tarp on the roof and hanging down on the east side of the house. 2 of the windows had AC units in them, and unknown if the windows worked properly. There was trash and debris on the property, and the trash cans were in public view. An error on my part, April 1st, when I did the inspection, was trash day. So trash cans are allowed to be out there, so that's kind of a moot point at this time. On April 1st, we mailed a notice of violation. We got return attempted. It was unknown. On May 13th, I conducted a reinspection. It was still not in compliance. At the time, the roof was still not complete. There was missing shingles and/or proper roofing materials. New fascia was installed in the window, and the AC units appeared to be in compliance at that time. Notice of hearing was mailed, return attempted, and we received nothing. On May 31st, I posted the property. On June 12th, conducted a final inspection, and the property is in compliance. At this point in time, the only thing before the board is the city's desire to establish the violations of 8-22, accumulation of trash, 8-40, duty to maintain private property, and 8-52, the nuisance prohibitions and all the conditions that go along with that. As I stated, all of those are currently in compliance, so there's no open cases with the property at this time. I strictly want to establish them for those 3 violations. And the city has nothing further at this time.
Understand? Do you have any questions, just questions for the officer? You'll get a
City or
chance to
for him?
present your case as well.
This question for the city or for,
Question for the city.
Yes, Officer Gasson.
one question is, he says he haven't been in touch with us, and that's not true. I've been on the phone with
No,
Beth.
do you
That's
have
not a
any
question.
questions for Officer Gasson?
What,
You will
when,
get
why,
the chance
where?
to present.
Question for him.
For him.
Yes.
Yes, first question is, I want to know, why did he put a violation on the trash cans when there was clearly no violation at all?
He did clarify that.
Okay, and I also want to know exactly where is the trash and debris on the property? Pictures.
Trash and debris is just anything, and there's a picture of the driveway that you probably reviewed in your photographs. At the time of the initial inspection, when I noticed that, there was just things laying around, there was chairs on their side, things like that. It's just general trash. Debris has a large definition, which includes any unused equipment. It can include, you should still have a set of pictures, I
Could you
believe.
pull up pictures?
Which picture would you like me to pull up?
Any one of them?
Okay, any one of them. Okay, let's see.
That's the picture from 2017.
You did say any one of
To
them.
date, please.
Okay. And I think we can probably, without being some sort of an engineer, I'm inclined to think that this is trash. There's this plastic, looks like a drawer set that I'm inclined to think is not used outside. There's these waste baskets, and it looks like a dog carrier and some other things. So I think that's probably would be reasonable for a person to assume that's trash. And/or debris, because as I stated earlier, you may not consider it trash, but if it's unused equipment or material, then it's debris, which falls under 8-52.
Oh, could I have that little flashlight? you
No,
got so I can,
I'm not, you can describe what you want to describe, but,
over there on the right, those are plants.
sir,
You can see it's also a grill on the right that you circled.
okay.
So
Sir,
I'm trying to figure out where's
I
the
pointed
trash
out
and-
the trash that you asked me to point out. If you want, I'm not saying anything about the grill.
to walk to the
I
board?
said certain things were trash.
This isn't the time
Trash.
to argue. This is the
Trash.
question time. Then you can present your case. You ask a question, he's answered that. Do you have a further question?
He said it may have been trash. Is it trash or not?
Do you have a question for the
Yes.
officer? And
How
he,
did he assume that that's trash?
all right. Do you have a further question? If not, now it's your turn to present your case.
Okay, could I pull up the same picture?
Yeah. Oh, I'm sorry, here's a wider shot of trash. Trash. I don't know what he's got a traffic cone in the driveway for. Hang on, I think I have a newer one where it's been cleaned up. but I'm not 100% sure, because that would kind of demonstrate that somebody apparently wanted to clean the trash up. Can't open the picture. Sorry, folks. I think I lost my network connection. So that's all I have of the driveway. So
Your turn.
He says I'm in compliance, but those same things are still there. The flower pots, all of the same things are still there. And he put them in compliance. And I have been talking to Beth the whole time since he said that we haven't been in communication. I've constantly been in communications with
said
Beth,
Thank you.
at least over 20 times.
Thank you. Do you have any questions for them?
no, he's in compliance.
Would you like to summarize your case?
As I stated, I'm here to establish this to prevent any future issues. I think the board's clearly seen that there was violations present. As I stated, he's in compliance. The city doesn't have any argument about the things that are there.
Understood.
It was previously, it's been taken care of. He's in compliance. We just want to prevent any further issues.
Thank you.
I have a question.
Do you have, okay.
If you say you want to establish it, that means that you, in the future, if there is a violation, that would make them a repeat violator. Is that the reason for establishing it?
That is correct.
Would you like to summarize your case, sir?
Yes. Pretty much me and Officer Gasson has a real rocky road.
Speaking to the
I
microphone.
said me and Officer Gasson has a real rocky road.
Objection to relevance.
Your case regarding your property?
Yes, I'm saying that he said that it was trash, and I'm telling him that it wasn't trash, and it's still there, and he complied it.
Okay.
So I think it was a false complaint,
All right, thank you.
along with the trash can.
The public portion of the case is now closed. Would the board like to entertain a motion, please?
I'll make a motion. I move based on the testimony, evidence, facts presented in the law, that at the time of the alleged violations, sections 8-22, 8-40, 8-52 of the Code of Ordinances of the City of Tarpon Springs were in full force and effect at the time of the notice of violation. The respondents were in violation of said code sections. However, they are now in compliance.
Second.
Bobby, roll call, please.
Mrs. Telliar?
Yes.
Mr. DeMasis?
Yes.
Ms. Norfleet?
Yes?
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Ms. Wade?
Yes. Owner?
Sure. So, sorry, ma'am. So you have been found in violation of the city code 822, 8-40, and 8-52 at the time of the violation, but you are now in compliance, so the board is not assessed you a fine.
Thank you.
Is that it?
That's it, sir. Next
Again,
case, we have it listed as case number 419-800000114-319 North Diston Avenue. Is Frederick Green here?
I don't believe.
Okay.
You ready, ma'am?
Would you like to submit your evidence, please?
It's coming around.
And
Case number
present your case.
19-800000114. The property address is 319, sorry, my watch tells me I have to move around. 319 North Diston Avenue. The property owner is listed as Frederick Breen. Exhibit number 1, going before the board, are my photographs. Exhibit number 2, notice of hearing and notice of violations. Exhibit number 3, administrative documents, case summary, property appraiser, and tax collector records, and a vacate order. Exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits are, well, he's not here, so there were none given to the violator. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of hearings and notice of violations are mailed both first class as well as return receipt requested. And Madam Chairman, please accept all these into the record as evidence.
Thank you, Bobby.
Yes, ma'am.
We have had contact with the owner via phone calls and emails. Originally, the case started February 15th of this year. There was debris and trash in the rear yard. There was a downed tree and another dead tree in the front yard. On March 29th, started the case over again. Because the sale order, there was a bank, I think it might have been a foreclosure issue, and there was a vacate order, so we had to start a new case. So the clock started over again in March. So on March 29th, a notice of violation and a notice of hearing were mailed. They were returned to our office signed. On April 26th, conducted a reinspection. Basically, there's no change to the property. It was still in the same state it was. On May 7th, the deferral notice was mailed. We postponed it for another month because the new owner had been working with us trying to get some stuff taken care of. So posted the property on May 31st. And as of yesterday and today, I drove by it this morning, there's really no change. Now, he had called and said he was going to start working on it today, and I can only assume that maybe the weather kind of created him an issue. And we were also trying to expedite a tree permit through Shannon because the tree in the front yard, he's going to need a permit to get it taken down. So I don't know what the status of that is, but he is well aware of it, understands the expeditious nature of it, and is working on it. Once he found out he was the owner of the property, I think it had to do with the death in the family, kind of a foreclosure thing. So he kind of adopted it, for lack of a better term. So what's before the board right now is the accumulation of trash under 822, 8-40, the duty to maintain private property, and 8-52, the nuisance prohibitions. I didn't specifically cite him any of the tree codes. I kind of put that under 852 with debris. So those are the only items before the board at this time for their consideration. Thank you.
Board have any questions for the officer? Summarize, please.
I have no summary. I think it was.
I'd entertain a motion if the board has one.
I'll make a motion.
Thank you.
I move, based on the testimony, evidence, and facts presented, and law, that at the time of the alleged violation, sections 8-22, 8-40, and 8-52 of the Code of Ordinances of the City of Tarpon Springs were in force and effect. The respondent was in violation thereof.
Second.
Bobby, call roll, please.
Mrs. Telliar?
Yes.
Mr. Demasis?
Yes.
Ms. Norfleet?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Yes. Ms. Wade?
Yes.
Motion carries.
We gotta do the penalty.
Yes, ma'am.
City have a recommendation for a fine or time frame?
I would say either 45 to 60 days, and then $50 a day. We've had no priors with them whatsoever.
There have been no priors.
We've had no priors, yeah.
Thank you. Would the board like to make a motion?
I'll make a motion. I move that the respondent shall have until August 15th, 2019 to bring the property into compliance with the code sections cited previously, or suffer a fine of $25 per day for each day thereafter the respondent remains in violation of said code section.
Second.
Roll call, please.
Mrs. Telliar?
Yes.
Mr. Demasis?
Yes.
Ms. Norfleet?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Yes. Ms. Wade?
Yes. Next item is listed as number 6 on your agenda, 19-80000204, 1431 Watermill Circle. Alana Lynn Sampson, is anyone here for that property? Yes. Thank you, and you've been duly sworn in, I think? Yes, ma'am. Thank you. So that he'll make his case, you can ask questions, then we'll come back to you.
She's got the photographs. She's got the evidence.
Photograph.
I did receive the evidence,
Okay.
and I am the property owner.
All righty, and you have no objection to the city submitting their evidence for the board?
No objection.
Thank
no.
you.
Didn't
Thank you.
really-
Case number 19-800000204, the property address 1431 Watermill Circle, property owner listed as Alana Lynn Sampson. Exhibit number 1 going before the board are all of my photographs. Exhibit number 2 notices include the notice of violation and notice of hearing. Administrative documents to include the case summary, property appraiser and tax collector records, and any related emails are exhibit number 3. And exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits given to the violator, exact copies of what's being presented to the board. All the notices were mailed to the property owner of record based upon the Pinellas County Property Appraiser and Tax Collector databases. All my notice of violations and notice of hearing are sent via return receipt as well as first class. And Madam Chairman, if you would, please accept those into the record as evidence.
Thank you, Bobby.
Yes, ma'am.
Thank you. We've had no contact with the owner. March 29th, the case started. Received a complaint about furniture out front, and there was repairs needed to the fence. When I did the inspection, there was no furniture out front, but I did note some issues with the fence. You can see in the photograph some pickets missing, and it just looked in poor condition. At that time, on April 2nd, we mailed a notice of violation. It was they attempted to issue it, but it was returned unknown. On April 23rd, I conducted a reinspection, noted the fence was still in poor condition, especially on the north side of the house. On April 24th, the notice of hearing was mailed, and again, the return was attempted, it was not known. May 31st, sign posted and affidavit of posting was completed. On June 12th, I conducted the final inspection, which these pictures that went before the board are from yesterday, and there are still some issues with the fence, missing pickets, and kind of in just generally poor condition. The only violation before the board today is violation of City Code 36.03, which is basically the duty to maintain your fences, walls, and hedges in a non-dilapidated condition. That's all I have.
Questions for the officer? Just questions at
Yes,
this
ma'am.
point. Okay.
Yes, Officer Gasson, who filed the complaint
Can you-
about?
You need to speak in the
Officer
microphone, please.
Gasson, sir, who filed the complaint about the furniture and the fence?
I don't have that on my notes because I usually don't care. So I would only be guessing.
Okay, sir, all due respect, how would I go about obtaining that information?
You can come into the office and Beth will be more than happy to give you a copy of it.
Okay, thank you, and I do apologize that I wasn't aware that this started in March. I was just aware of this, but that, I believe, needs to be in the summer.
Just questions at this
Right,
point.
sure,
Okay.
no more questions, thank you.
Any other questions? Then you
All
can,
I see is about 5 planks
Wait.
that need to be replaced.
Wait. now
Right,
you're
but
testifying.
is that what, I just want to make sure I'm asked, is that what it is?
Here's the one thing.
5 planks.
There are parts of it I can't see, but if at some point in time your neighbor says, hey, look at this or something, so I would make sure that your whole fence that you own is in good shape. So I can only testify to those 2 parts right now, but that may change. So just understand that when you're fixing it.
Okay,
Now, you'd like to present your case?
yes, please.
Thank you.
Thank you, I appreciate it. And I apologize that it got to this. I would have fixed it a lot sooner. There's a few barriers, a few struggles that we have.
You need to speak in the
I
microphone.
have a few, okay, and I just want to apologize that it took this to fix my fence. I'm a single parent of 5 kids. I received no support. I'm the sole provider of 4 children, 10 and under. So my time is a very big commodity. I had no idea that it got to this level of needing the board and everything. I apologize for that, first off, because I didn't realize it was this serious, so I apologize. Secondly, if I could ask for a bit of an extension to fix the fence, because I have a few barriers. Number 1 is money, because all my money goes to paying the bills to support my children. I don't receive help like from their father, and that's okay. The fence on the south side of the property, excuse me, the problem was we had a fire. Well, my son's friend had a fire, so the fire department came to do their duty to check the fire, and they like broke the fence down. So we tried real hard to put it back together. Excuse me, to put it back together. And I did not realize that it was like, okay. I didn't
okay. It's
understand
okay. That's all
the
right.
tremendous like intensity of planks of the fence. So I will fix it. That I can do. But it's the time. And recently, every time I get home from work, I'm trying to feed 5 kids and get them bathed and in bed. So by the time I'm ready to fix something, it's about bedtime. So that leaves me Sunday. So this past couple of Sundays, weather has not been good. But that doesn't explain, March and April and May. I didn't realize I was even being, told to fix it, and that's my fault. But if I could ask for a bit of an extension to fix it, I'm pretty sure I can fix it. Now on the south side of the property, the thing is there's a pool. My neighbors have a pool. And like I just said, I have 4 kids, 10 and under, my youngest being 4. I'm concerned when I pull that fence down and they're seasonal neighbors, so they don't live here. I don't know really where they live. So when I tried to get permission to fix it, because in my neighborhood is a HOA, so I have to get permission from all my neighbors to fix, the prop, or to fix the, I didn't really, let me back up. Whenever I'm supposed to do modifications to the property, I have to get permission from all the neighbors around. Every time I went to talk to the neighbor who just bought the house, they are out of town. Like, they don't live here. So that's that's like a barrier that I need to figure out how to get a hold of them, because actually that part of the fence is on their property. Even though, like, if you look at the property itself and like the engineering or whoever, okay, I don't know how to explain this because I'm not a engineer, but like the property itself on the south side, I let my neighbor have 1.5 foot of the property because they couldn't access the air conditioning. So really the fence itself is on their property. It's not on my property, the south side. The only reason I was scared to take the whole thing down is because that would present a problem with there being a pool where my 4-year-old can all of a sudden now she's in that yard. That's what worries me the most, of taking the whole fence down. So if I could have permission to repair everything that I can, it'll have new boards with the old boards. Because unfortunately, I don't have the money to buy a new fence.
And about how long do you think this would take?
So my next barrier would be the financial part. So, I mean, if I could have till the end of the summer, possibly maybe July, August, because we're already at the end of June. So I would need at least
30 days?
60 days, possibly.
Days? Okay.
I mean, the other thing is, if I would have known it got to this, I would have called Officer Gasson. Like, now I feel terrible that I wasn't in contact, because I feel like it didn't have to get to this. This was my, so if I could have a little time to fix it, I can definitely fix it.
Thank you.
Thank
Officer Gasson, would you like to summarize?
No, I do not.
Any questions for either one?
If the fence is on someone else's property, what responsibility does she have for that?
None.
So
If it's not hers, and I don't understand the HOA rules, and we don't get into the HOA rules about, I would just say I have a little bit of a weird spot about repairing your own fence and having to get permission to repair a fence from your neighbor, but I also don't know anything about their HOA. So if it's your fence, you're responsible for it. If it's not your fence, then I write the neighbor up. But I have to have a survey to prove that, unfortunately. I can't just guess. And unfortunately, surveys are hundreds of dollars.
And most HOAs, if you're fixing something, it's different than if you're altering something.
Correct.
So,
Might I volunteer a comment that
Please.
might be helpful in regards to the HOA? I spent some time rewriting the covenants of my own HOA that I'm a member of. I would strongly suggest that before the respondent needs to get permission from her neighbors in regards, she should seek out the advice of the board, the homeowners association that she belongs to. And I think she may find out that will be sufficient, and that the board can make a ruling that would cover her actions in the future in regards to repairing her fence. And I think if she makes that known to the board, let them seek out the neighbors if in fact they need to have the neighbors' approval. But I would start with the homeowners association. And there's an old Greek saying, don't talk to the feet, talk to the head. So you get the top person in the homeowners association, and you tell them that you've been in here and you have whatever number of days we may or may not grant you in order to make these repairs, and you need some cooperation from them.
Okay, thank you very much. Thank you.
I'd like to close the public portion of this and So you might like to make a motion?
I'll make a motion.
Thank you.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violations, Section 36-03 of the Code of Ordinances of the City of Tarpon Springs was in effect, and that the respondent was in violation thereof.
Second.
Did I hear a second?
Yes.
Thank you. Bobby, call roll, please.
Mrs. Telliar?
Yes.
Mr. Demossis?
Yes.
Ms. Norfleet?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Ms. Wade?
Yes. Now, as far as the penalty phase?
I would,
I would suggest September 18th of 2019, which is 90 days approximately, and like $20 a day.
Okay.
I would like to make a motion, if I might, Madam Chairman. I move that the respondent shall have until September 18th, 2019 to bring the property into compliance with the code section previously cited, or suffer a fine of $20 per day for each day thereafter the respondent remains in violation of said code section.
Second.
The motion's been made and seconded. Would you call roll call, please?
Mrs. Telliar?
Yes.
Mr. Demossis?
Yes.
Ms. Norfleet?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Wade?
Yes.
Motion carried.
Summarize for the.
And ma'am, do you understand?
Yes.
So you have until September 18th to fix the fence, otherwise it'll be a $20 per day violation.
Okay, and can I have one more question of, do I owe anything right now?
No.
Okay, thank you. Thank you very much.
If you have questions, you can contact
Can I
them,
talk to him now?
or you can go
Okay, thank
into
you.
their office. It's at the police department.
Okay, thank you. Thank you very much.
Thanks for coming.
Thank you.
We'll move on to item number 8 on the agenda, which is a vacant lot on Lincoln. The item number is 19-8000317. Craig Fowler Jr. doesn't appear to be here. Do you have any evidence to submit? Thank you. Bobby will accept that, and Officer Gasson will make his case.
Hello. Sorry, it's catching up. Case 19-8000317. This is a vacant lot on Lincoln that borders around the little ice cream shop that's there. Originally, exhibit number 1 are all of my photographs. Exhibit number 2, my notice to include notice of violation, notice of hearing. Exhibit number 3, administrative docs, the case summary, property appraiser, and tax collector records, and any associated emails. Affidavit of posting and a copy of the sign is exhibit number 4. All the notices were mailed to property owner of record as provided by the Pinellas County Property Appraiser and Tax Collector databases. All my notice of violations and notice of hearing are sent return receipt, and as well as first class. And Madam Chairman, please accept all these into the record as evidence.
Thank you, Bobby.
We had phone contact with the cousin of the property owner. The property owner of this vacant lot is Mr. Craig Fowler Jr. On May 9th of this year, I got a complaint about trash and debris dumped on the property. There's an old grease storage container, antenna, chairs, as well as some other trash and debris. Mailed the notice of violation on May 9th. On May 28th, conducted a reinspection. There's still trash on the property. The cooking oil vat was still there. On May 28th, the notice of violation was mailed. No mail was returned to our office. On May 31st, I posted the property and an affidavit of signed posting. Conducted a reinspection on June 11th. There was still some trash on the property. The grease trap, dump, whatever it's called, I don't know the exact real name for it, but it looks like a little dumpster and it says grease. So, and there's no associated restaurant business. This is a vacant lot. The only thing that's on it is a shed and a grease trap or dump or whatever. There is a small little restaurant or the ice cream shop off to the side, but I don't know the association, so you can't have that on there when they don't tie together. I took some photographs, and then they went out and cleaned up a lot of the trash. So when I did a reinspection this morning and drove by, I'm going to put into compliance the accumulation of trash. They did get all of the trash taken care of. So before the board, the only violation I'd like them to consider is 8-52, specifically because it defines debris, which is unused equipment. Since there's not a restaurant on the property, I'm tying together the grease trap as unused equipment. So basically, the only thing to bring that property in compliance at this point is to remove and properly dispose of the grease trap or put it wherever the business is that's licensed to have it. So that's all that's before the board is a violation of 8-52. As I stated, 8-22 is not for consideration. And that's all I have at this point.
Anybody have questions for the officer? Would anyone like to make a motion?
I'll make a motion. I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, Section 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Thank you. If there are no questions, we'll make sure we clarify that this is only for 8-52. And Bobby, if you call roll, please.
Ms. Telliar?
Yes.
Mr. DeMasis?
Yes.
Ms. Norfleet?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Ms. Wade?
Yes. And we need to have a second motion with the compliance or finding issue.
I'll make the second motion. Do you have any recommendations?
30 days and whatever fine you get. There's no open priors on the property for this, so.
Okay. All right, I move the respondent shall have until July 19th to bring the property into compliance of Section 8-52, no nuisance prohibition, or suffer a fine of $25 a day.
I second that motion.
Roll call, please.
Yes, I'm just jotting down some
That's right.
information, sorry. Gotta get that in first. Ms. Telliar?
Yes.
Mr. DeMasis?
Yes.
Ms. Norfleet?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Yes. Mrs. Wade?
Yes. We'll move on to item number 9. It's a repeat violator. It's item number 19-8000339-1717 Mandalay Drive, Seeking Lee. Is anyone here for that property? Thank you. She's,
She was.
I thought she was. Do you have any objection, ma'am, to the city's evidence being placed into the testimony for today?
Yes,
You have an objection to that?
I have objection because I didn't receive the information until right now before the just few maybe half hours ago. So I need somebody to review it to discuss.
So would you like us to move you later on the agenda, and at the end of this meeting, we
think
can
this
come
is-
back to you?
The last one. on
No,
the agenda.
because I need to consult my legal counsel, and I didn't receive this package until just here right now, so I need to.
That's normal. We give the evidence that's being presented to the board to the violator at the code board hearing. And she's been in contact with our office as soon as she received the notice of violation, so she could have asked for it and had the exact same information well ahead of time.
But I didn't receive this package until just I signed in.
That's the normal procedure.
Dan?
But I'm a foreigner. English is my
They're
second
pictures,
language.
ma'am.
Sorry,
They're photographs.
photograph.
It doesn't matter if they're in English or Arabic.
But they also have all kind of document here. I need somebody to review it.
And those have all been sent to you previously. Those are all documenting the documents that were sent to you. Those
the
are
on-
copies of what you've already received.
The information I received is this: the notice of hearing, and about this new stuff. I need to review it.
Okay,
Like
so
this.
Officer Gasson has entered the evidence in the record. She's objected to it, so you can rule on the objection.
I'm
Overrule
going,
the objection if you'd like the evidence to come in, or you can sustain the objection and not allow the evidence to come in.
go with the, objections overruled, we're going to allow the evidence to come in.
Okay.
Thank you.
Present your case, sir.
All right, first off for the board, this case is case number 19-800000339. It was established as a repeat violator under case 16-8000292 for violation of City Code 8-40 and 8-52. Previously, this case had been went through a substantial amount of litigation, went through the code board and everything, and it had been fined $100 a day previously, and there was a settlement offer that was made for $1,000, and that previous case was settled, but she was established by the board. The property address is 1717 Mandalay Drive. You folks may remember this as the pillar property, had a number of pillars on the property. Those have since been removed. That established the compliance previously. What brought the case before the board today is it was overgrown. Exhibit number 1 going before the board are all of my photographs, which consist of 1. Exhibit number 2, notice of violation and notice of hearing. Since this is a repeat violator, they get the repeat violator notice of hearing, and they're all together. It's one document. There's not separate ones like a new case. The administrative documents, case summary, property appraiser, tax collector, and tax appraiser records, and any associated emails, affidavit of posting and a copy of the sign, and then also the affidavit of prosecution costs is exhibit number 5. All of the photographs and exhibits that were given to the violator, exact copy of what's been presented to this board. All our notices are mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All of my notice of violations and notice of hearings are sent via certified mail as well as return receipt. And Madam Chairman, please accept all of these into the record as evidence.
Thank you, Bobby. Does the board have any questions for Officer Gaston?
Yes, I have a question, Officer Gaston, just so that I understand the intent of the allegation. Where what it indicates that the two city code ordinances were complied with on 5/28. Is there a period of time when they weren't in compliance?
That's correct. My case started on May 21st. I got a neighbor complaint about the property being overgrown, and I inspected it. And at that point in time, I determined on May 21st that it was in violation of 8-52 and 8-40 being overgrown. I don't know if you want me to continue. Does that answer your question?
Yes. What I'm trying to determine for myself is if the respondent is found guilty, I see that it indicates that the affidavit of prosecution costs were $69.50. Are there additional costs in fines that have been established already, or?
Not unless this board finds that the violation occurred and the board determines that fine for that repeat violator for the period of the 7 days that I documented they were in violation. Because I hadn't given the rest of my case yet, so.
Oh, all right. Well, then.
And I might explain some of it in that process.
Patiently until you've completed, and perhaps my questions will be answered. Thank you.
You're welcome. Can I go forward, ma'am?
I thought
Okay,
you
so
were
as I
finished.
stated, we have had contact with Melody Marsh. She's contacted the office numerous times and spoke to Beth, so she was well aware of the violation and what was going on with it. On May 21st, the property was overgrown. It was not being maintained. Created the repeat violator notice of hearing, which was mailed. We didn't get any return mail on it. On May 28th, we received a phone call stating the property was ready for a reinspection, and that was the date that I used as the complied date. It's like I typically always do. If that's a date they tell me, as long as I go out and it's in compliance, that's the date I use. So on May 29th, I did go out and conduct the inspection, and as I stated, it was in compliance, so I used the May 28th date. On May 31st, I posted the property and signed the affidavit of posting. So the violation started on initial inspection of May 21st. It was complied on May 28th for a total of violation days of 7 days. City Code 8-40 and 852 are currently in compliance, and as I stated, it's a repeat violator, so for those 7 days. And that's all I have.
Board has any questions?
Does the board have any other questions? Do you have any questions for the officer?
I do.
This is just questions. You'll get a chance to present your case. Just a question this time.
Question. Actually, I come here to request this case to be continued, to postpone for next month, because I got confused for a repeat violator.
So, ma'am, you can request that in your presentation, but right now, do you have any questions for Officer Gaston?
Is there any reason for you not return my phone call?
Yes.
Why?
Because you've been clearly told we want to communicate with you via written responses, because you have a tendency to take things out of context and create your own narrative. So to prevent that, we want everything in writing so that it can be presented for any possible hearings or court appearances.
Who instruct you everything have to be in writing?
That was told to you before when we were dealing with your previous case when you had the meeting with Major Trill.
So Major Troll instruct you, Major Troll instruct you, all the communication have to be in writing?
No, he instructed you.
He didn't,
That was the answer to the question, ma'am. I can't tell you anything else.
Now, would you like to present your case?
I don't want to, I want to the case to be continued for next month.
I would object. The city would object to that because we've prepared. We've done this numerous
I
times. She was
sustain the
well over that.
objection.
Thank you.
Do you have a case you'd like to present?
Yes.
Okay.
Good afternoon, City Attorney and co-board member. My name is Melody, and I'm the owner of daughter. And today I come here with, I would like to ask this case to be continued because it's very confusing. In 2016, according, I got this letter showing in 2016, establish a repeat violator. I never ever received any communication because on that year, I'm a survivor of domestic violence and my husband is very dangerous.
Objection to relevance to
Nothing
this
to do with
case.
the case,
Yeah,
ma'am?
so I didn't receive any of the communication. I've been
Again,
running-
this is a 2016 case she's referring to. We're here
About
for
the
this
case
case.
that's being brought now, which is the yard hasn't been maintained. You've been notified. Do you have any comment about that?
Yeah, but this case is related repeat violator back to 2010, August 18, and which is I never received any notification
Okay,
for
the
established.
case we're dealing with now is 2019.
Yeah, but this case is related. So when I
That case was concluded, a finding was reached, and now you have not complied again. So this is a whole new case. It has a new number and everything.
Yeah, but this is a established repeat violator. So I didn't know I'm a repeat violator because I never received any communication.
That's not our fault. We have complied with the law and notified appropriately.
And the other reason is I have my lawyer to handle the entire case. And because I'm a patient of PTSD, I don't have any strain. So whatever Steve Gasson want me to do, I comply everything. From he want to destroy the entire foundation, I did exactly he want me to do. He want me to hire the lawyer to be communicate. I hire the lawyer to communicate. He want me to do everything. I follow everything what he want me to do. I bow down on him. And I give this case entirely to my attorney. He should handle everything. And now I don't know.
Since your attorney's not here and you're speaking for the property, we're only dealing with this period from 5/21 to 5/28.
That's what I need to find out why my attorney will left this behind for a repeat violator because he knew that I never received communication and the city foreclosed my mother's property.
Okay, has nothing to do with this case.
Yeah, for the assessed fine for over 60,000 when I find out of that.
This has nothing to do with this case, ma'am.
Yeah, this case is, they said, as a repeat violator, but
We understand that.
the point is I never received any communication. How can they establish me as a repeat violator?
Thank you.
And that's why I need to talk to my previous attorney, Andrew Zansman, to find out what happened.
Okay.
So they need time to discovery. And that's why I request a board member allow me to talk to my attorney to find out all the detail so I can present my case properly.
Ma'am, the yard was not maintained. It has nothing to do with your attorney. We have evidence that you have been brought here before for the same issue. Again, the yard was not maintained. This is the procedure that takes place. Thank you.
I know exactly what's going on because in this month, in middle of May, I talked to my neighbor, Don. I asked him how high is the grass. We have communicated because I cannot afford to have any issue. My mother is 80 years old. I live in Wisconsin. I don't live in Florida.
None of this is relevant.
So, so my neighbor tell me on around middle of May, he said the grass is about 5-6 inch tall. So I said, oh, so this year must be have to. Usually we started on June, but this year we have to start early. So we have I have the lawn maintained at the Memorial Weekend, which is after Steve Gasson do the inspection. And this is what happened in the past because it's a vacant lot. It's maintained once a month. It's not the house there, so always been like this once a month. And that what exactly happened each time is when my service mow is a day or two after he do the inspection, and that's exactly what happened. Same like this time, like he do the inspection on the 21st.
We understand. Thank you.
But the lawn already been maintained within few days, within 6 days. The 28th already, and that 3 day is a Memorial Weekend too. So I didn't know about the notice for hearing until the 28th. I received this notice on the 28th of May. That's why I called the city to do the inspection for the incompliant. But I didn't know that. We already scheduled with the conversation with neighbor to
We
maintain.
understand, ma'am.
So,
Thank you.
So the 6th day and 3 of the day is already a Memorial Weekend,
Yes, ma'am, you stated that already.
which is not like a long period of time. We try very best to do, especially my mother was 80 years old.
Not related to your mother. I'm going to have to cut you off because you're repeating the same thing over and over. Thank you.
And I just want to let you know, like, we just, my mother just demolition.
Not about your mother. Please don't bring that up again. This is about this property.
The
Thank you.
foundation damaged over 200-some thousand because Steve Gasson wanted to do. So,
Thank you.
So, you know,
I'm going to call for the board to, do you have a recommendation?
and excuse me, and because I came here for comply whatever Steve Gasson and Michael Troll and take me in here over here to asking me to be comply, and I lost my divorce case.
Ma'am,
and
this has nothing to do with
okay.
any of that. Thank you.
I just
You're gonna
want
have
the
to-
member
you're gonna
to
have
be
to cease your
helping
testimony
me
when you're
helping
off
me
track.
out
Thank you.
because I need the board member to understand and
I'm
helping
sorry,
me
ma'am.
out.
And then,
You've made your case.
and then I would end public comment.
And
if you'd like.
we've ended the public comment. The board will make a decision. Thank you.
Previously, the fine was $100 per day. The board was well aware of this case. She was present before this board when she was advised by Mr. Trask that any cases moving forward be a repeat violator. She's well aware of Florida state statute. She had an attorney who dealt with her settlement. She was well aware of all those
Yes.
aspects for the board that may not have been present for that original hearing. So just to educate the board a little bit on that, she's well aware exactly how this process works. Previously, the fine was $100 per day. As I stated, there was a settlement offer for that. The city would request, because this obviously is going to probably still continue to be an ongoing problem, the fine of $150 per day on an increasing scale for those 7 days.
Thank you.
I would like to ask you a
No, ma'am,
question.
you're finished. Thank you.
I need to present my case if you.
Your case has been presented. The public testimony has been closed. It's our turn to rule at this time. Thank you.
I just want to let you know, in February,
Ma'am, you-
the U.S.
Ma'am.
Supreme
Ma'am, you're
Court
out of,
ruling
out of
the
order.
Eighth Amendment
you-
prohibits city
I'm
from
going to have to
capacity
ask the
assessed
officer to
fine.
escort you
He-
out if you continue to interrupt.
He pros $100 a day for over 90,000,
ma'am,
and
you
we
need to
just
stop. The public testimony is over.
Sir, would you have her escorted out, please? Thank you. Would the board like to make a motion, please?
I want to finish. I need to listen.
Thank you.
First.
You want your first?
I need the co-board member to support and understand what my life goes through.
Would anybody like to make a motion?
I'll try to make a motion on this. I move that based on the testimony and evidence and facts presented in law, that the respondent was in violation of section 8-40 and 8-52 of the Tarpon Springs Code from the date of 5/21 to 5/28. And then I'm fining her $200 a day. Of a fine of 200. In addition, I move that the city be awarded $69.50 in court costs.
Second.
Roll call, please.
Mrs. Tellier,
Yes.
Mr. DeMossis,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Wade.
Yes. Now we'll do the affidavits of non-compliance. Lump all those together. No, one of compliance I can clump together, right? Next agenda is item number 10. It's case number 18/-800000869, 707 Chesapeake Drive, Steve L. Smith Trust. Is anyone here for that case? Would you like to?
Oh, it's just an affidavit of noncompliance.
Oh.
They're not in compliance.
I move the affidavit of noncompliance in the case numbered is accepted, and the city is awarded $142 in prosecution costs.
Second.
Roll call, please.
Mrs. Tellier,
Yes.
Mr. DeMossis,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs.
Yes.
Mrs. Wade.
Yes. Next item is number 19-8000146. Property is at 1739 Meadow Oak Lane.
I move the affidavit of noncompliance in that case number be accepted, and the city be awarded $166 in prosecution costs.
Second.
Chair, before you rule on that, was there anyone for this property in the audience? Okay, just want to make sure for the record that there was.
He works for the city.
Mrs. Tellier,
Yes.
Mr. DeMossis.
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs.
Yes.
Ms. Wade.
Yes. Now, we're going to group all the affidavits of compliance together.
Nope, not the ones with money.
They
There's
shouldn't
just
have
one
any.
that has prosecution
They
costs.
complied.
14 has money.
Yeah, number 14.
Oops, so I'll skip that one and do the others. This will be for 16-8000007, 987 Sunrise Drive, Hanan Bashai. Item number 13, which is 18-800000854, 785 Dodecanese, Bob Intervivos Cartes Trust.
I move we accept those two affidavits of compliance.
Second.
We can do it by voice vote. All in favor?
Aye.
Opposed? And the final item on the agenda for today
Thank you.
is an affidavit of compliance for property 18-8000516, 437 East Boyer. Ricky A. Taylor and John A. Conklin.
I move we accept that affidavit of compliance and award the city $193 in prosecution costs.
Second.
Voice vote, please. All in favor?
Aye.
Opposed?
Leave the motion to quash has already been picked up with.
Yeah, we just changed it. We moved that. It made more sense to put it before.
Have a, looks like approval of minutes.
Ah, we have 2 sets of minutes to approve.
That's you.
Would anybody like to make a motion to approve the minutes for April and May?
I move that the board approve the minutes for April 11, 2019, and for May 9, 2019.
Second.
Voice vote. All in favor?
Aye.
Aye.
Opposed? Minutes are approved. Anybody have anything else?
Yes, Madam Chairman, as I indicated to you in a brief conversation just prior to the start of this meeting, this will be my last meeting. My wife and I are unfortunately in a situation where we're going to be leaving Tarpon Springs and moving back up north, which is going against the tide, but nonetheless, I'd like to go on the record as indicating that I have enjoyed my previous term, which was 2 years on the board, a year as vice chairman, and then a year as chairman. I'm happy that the board took it upon themselves to allow me to take part, and I appreciate working with all the people. Some I've only just met, some, as like Mr. Kramer, has been a colleague for many years on this board. So I appreciate it. My last meeting, and I wish you all the best of luck. I think that this particular board does great work for the city of Tarpon Springs. I believe that the officer that's our inspector does great work, and all of his staff, and I appreciate the efforts of the board, and I was glad to be a part.
Thank you so much for your service. You've given back a lot to your city. We appreciate it.
It's one of the reasons why I took such an active part today, because I knew this was it for me. Thank you.
Seeing there's no other business on the agenda,
I'm sorry, did you ask for public comments? It is on the agenda. There is one person from the public here. So.
Yeah, do you want to say anything,
he's
Dave?
from the
Oh, I'm
city.
sorry.
He works for the city. He's not allowed to talk.
I'm sorry.
We
right, then there you
recognized
go.
him. You didn't have that.
See, that's right.
Seeing there's no other board business, meeting's adjourned. Thank you.
Thank you. Great job.
Right.
Mr. Weeks owes me big time.
Okay.